Mr. Murr, you have 60 minutes.
Mr. President, Senators, today is an important day. On this day in 1836, Sam Houston, whose Bible you used for your oaths today, was elected President of the Republic of Texas. Today is also an important day because we begin this impeachment trial. While impeachment is rare, the drafters of our state constitution recognized that there are times when this extraordinary remedy is needed to protect the state and its citizens from a public office holder who has abused the power of his office by putting self-interest above that of the people of Texas. The drafters concluded that this great deliberative body, the Texas Senate, is best positioned to determine when this remedy is appropriate. Earlier this year, Mr. Paxton came to the legislature seeking $3.3 million in taxpayer money to settle a whistleblower lawsuit. Mr. Paxton would not answer any questions about the underlying claims. He had successfully blocked any discovery in the case for almost 2 years, and he refused to justify the settlement. The House investigated the serious allegations raised by the whistleblowers. The House uncovered egregious misconduct and abuse of office by the Attorney General of the state of Texas and voted overwhelmingly to prefer articles of impeachment to the Senate. This is why we are here. The allegations in the articles reveal that the state's top lawyer engaged in conduct designed to advance the economic interests and legal positions of a friend and donor to the detriment of innocent Texans. Mr. Paxton turned the keys of the Office of Attorney General over to Nate Paul so that Mr. Paul could use the awesome power of the People's Law Firm to punish and harass perceived enemies. I was raised in rural Texas, where a person's honor is more important than money, where integrity matters, by a family deeply affected by political corruption. This is precisely the type of grave official wrong that our Texas Supreme Court has said warrants impeachment. My grandfather, who was privileged to serve the state of Texas for many years, had a favorite quote from Abraham Lincoln. Nearly all men can stand adversity, but if you really want to test a man's character, give him power. Mr. Paxton has been entrusted with great power. Unfortunately, rather than rise to the occasion, he has revealed his true character. And as the overwhelming evidence will show, he is not fit to be the Attorney General for the state of Texas. Mr. Paxton argues that the Senate should not exercise its constitutional duty to decide whether his conduct merits impeachment, because voters were aware of the allegations and still reelected him. He claims that the Senate should abide by the alleged will of the voters. However, this ignores the intent of our framers of the Constitution. Impeachment was included in the Constitution after the Founding Fathers debated and rejected the idea that elections could singularly protect the public against abusive office holders. In other words, drafters agreed that impeachment was and is necessary to protect against abusive officials because it was simply too easy for them to use the powers of their office to conceal the truth until after the next election. The concept of the forgiveness doctrine is not in our Constitution and does not apply here. The courts have made that very clear. And even if it did, the doctrine presumes that voters know all the facts. The voters did not and do not know the whole truth. Mr. Paxton went to great lengths to hide his misconduct from the public. The evidence will show that he used massive resources of his office to prepare and issue a sham report that allegedly exonerated him. The evidence will show that this report contains false and misleading information about the allegations against him and about the whistleblowers themselves. And he also lied about the independent nature of this investigation. Documents will show that he played a key role in drafting that report. The Constitution says the Senate has the power and the duty to decide this case and to protect the people of Texas from someone who has violated his oath and has shown he does not respect the law. The witnesses and the evidence will show you that Mr. Paxton's conduct merits the exercise of that power. And the witnesses and the evidence will show and prove beyond a reasonable doubt that he should be removed from office and prevented from ever holding a position of trust in the state of Texas again. Mr. Paxton argues that the articles do not allege impeachable conduct because they do not allege that he committed a crime. We do allege that he committed crimes. We have detailed that Mr. Paxton received favors, including home renovations and help in concealing and continuing an extramarital affair, in exchange for the Office of Attorney General punishing Nate Paul's enemies. However, we don't have to show some type of quid pro quo to establish that his conduct should result in impeachment. As the Texas Supreme Court made clear regarding the impeachment of Governor Ferguson 106 years ago, wrongs justifying impeachment don't have to be crimes. Wrongs justifying impeachment are broader than that because they have the purpose of protecting the state, not punishing the offender. Mr. Paxton should be removed from office because he failed to protect the state and instead used the power of his elected office for his own benefit. And this was wrong. The oath of office that we all took to protect the citizens of state and to uphold the laws of this state and this Constitution means something. It isn't just words on paper. It's literally an oath to God. And Mr. Paxton had an obligation not to abuse his office for his own benefit. He betrayed his constituents and the sacred public trust that's been given him. And in Texas, we require more from our public officials than to merely avoid being a criminal. The witnesses you will hear from are remarkable people. Until they refused to follow Mr. Paxton's wrongful demands, they were his most trusted, hand-picked advisors, and they believed in his conservative mission for the office of the Attorney General. The problem isn't that their commitment to conservative governance changed. It is at the end of the day, Mr. Paxton wasn't the man they thought he was. And he wasn't the man he publicly proclaimed to be. His trusted advisors are not rhinos or part of some deep state storyline. They are movement conservatives guided by their faith. These witnesses will explain step by step how they discovered that Mr. Paxton grew increasingly intent and passionate about helping his partner, Nate Paul, escape civil and criminal legal troubles that he was facing. They will describe in chilling detail when they connected the dots of Mr. Paxton's slow creep of corruption. The senior staff were outraged when they discovered that Mr. Paxton had directed a young, inexperienced outside attorney to obtain grand jury subpoenas to harass and interfere with an ongoing criminal investigation. Subpoenas that had been improperly issued to DPS officers, a federal judge, attorneys involved in a civil lawsuit against Nate Paul, and even court staff. And the subpoenas sought intensely personal information, including cell phone and email records. Now, I'm not going to detail in this opening all the allegations against Mr. Paxton. You're aware of many of them. You sit as a unique jury, having known Mr. Paxton and familiar with some of the facts. But even a quick summary of some of the evidence that you're going to hear is shocking. One of Mr. Paxton's many acts of deceit involved a member of this chamber. At a time when the policy of the state was Texas is open for business during COVID, Mr. Paxton directed his staff to issue a legal opinion advising that statewide foreclosure sales not move forward. Mr. Paxton was adamant that the opinion, which came to be known as the midnight opinion, be issued before the end of the weekend, just in time for Nate Paul to use it to avoid a foreclosure sale the following Tuesday. This conduct benefited Nate Paul, and it harmed businesses and people impacted by foreclosure. Mr. Paxton also used the power of this office to harm a charity solely to benefit Nate Paul. The Office of the Attorney General is charged with the responsibility of intervening in lawsuits when it's necessary to assist a charitable organization. As you'll hear, the first and only charitable case Mr. Paxton took a personal interest in was the Mitty Foundation's lawsuit against Nate Paul's entities as an investor. The evidence will show that Mr. Paxton directed his office to intervene in the lawsuit, to stay the case, and allow the AG's office the opportunity to pressure this charity to accept a lowball settlement offer. This would have saved Nate Paul millions of dollars. The creep of corruption continued when Nate Paul wanted access to confidential investigation materials related to police raids on his home and businesses. In an attempt to learn what the police knew and how they knew it, Mr. Paul submitted multiple open records requests seeking the full police file. Even though no police file may be disclosed due to the well-established law enforcement exception, Mr. Paxton pressured his deputies to authorize the release of this information. Had he succeeded, Mr. Paxton would have created precedent allowing any person under criminal investigation, whether for a violent felony or a sex offense, to obtain confidential information about the investigations of their conduct. Mr. Paxton simply did not care that his request to release information to Nate Paul would have put police and victims across the state at risk. Unfortunately, the House investigation revealed that Mr. Paxton's relationship with Mr. Paul was far more extensive than even his closest advisors knew. Over the course of 3 months, Mr. Paxton personally met with Nate Paul more than 20 times. Many times, Mr. Paxton would ditch his security detail. And Nate Paul even set up a secret Uber account that allowed Mr. Paxton to secretly visit Nate Paul and others. To conceal his efforts, Mr. Paxton communicated in off-the-book ways, using burner phones, encrypted messaging apps, and secret email addresses. Mr. Paxton's brazen abuse of the Criminal Justice Division at the Office of Attorney General is finally what caused 8 of his senior staff to report him to the police. The question that haunts them and should frighten all of us is what would have happened if they had not reported him? How far would Mr. Paxton have gone in using the power of the Attorney General's office to harass and punish his and Nate Paul's perceived enemies and hurt innocent Texans? Mr. Paxton tries to defend his actions by isolating each event and claiming that standing alone they can't support impeachment. You cannot and should not view each act in a vacuum. The evidence will show that they are all connected. They're all connected by Mr. Paxton and his desire to deliver for his partner, Nate Paul. Mr. Paxton will also argue that the acts represent differences of opinion on policy or efforts to help a constituent. But the witnesses will explain to you that Mr. Paxton's actions have nothing to do with implementing conservative policy. And in fact, his efforts violated those very principles. Mr. Paxton's senior advisors were fully aware of the dire consequences of reporting him to law enforcement. They knew retribution would be swift and vicious. The choice they made to report him to the police was one of the hardest of their lives. But they will tell you that there really wasn't a choice at all. Sam Houston, who on this day in 1836 was elected president of a new and free republic, reminded Texans, do right and risk the consequences. Do right and risk the consequences. Doing the right thing is sometimes not easy. Sometimes we must do the right thing in the face of enormous pressure to remain silent. The witnesses felt this pressure. The House felt this pressure. And the Senate is feeling this pressure. It's unfair and it's wrong. But despite the forces that seek to intimidate the Senate, you have taken the first steps toward the truth by giving the people who did the right thing a chance to testify. Despite the attacks that they know will continue to come, the witnesses will do the right thing once more. And they will take this witness stand and they will provide the clarity that the Senate needs and that the public deserves to find out what was really happening behind closed doors. As chair, I resolutely give this statement with the support of and on behalf of the Board of Managers and on behalf of the Texas House. You all provided us with an hour to make an opening statement, but we prefer to yield back the rest of that time to the most important folks that will show up in this room, the witnesses. The same witnesses that Mr. Paxton has been so desperate to discredit and intimidate and to silence. We are honored to be able to give them their day in this honored and rare court where we simply seek justice on behalf of the people of Texas.